Today's question is, after filing for legal separation or divorce, where is my child going to stay? I have my child with me right now. How is custody going to work after separation? The question of what the court will do regarding child custody is premature. The first question you should ask is, 1, can the other parent and I reach our own agreement on custodial and visitation arrangements? And if you and the other parent cannot reach agreement, then the second and third questions you should ask are, 2, what custodial and parent time arrangement is best for the children, irrespective of what I may desire? Because that's essentially the question the court will try to answer in fashioning its custody and parent time award. And the third question should be, am I willing to spend thousands, maybe even tens of thousands of dollars to fight over the issues of child custody and parent time? If you and your spouse or the other parent cannot agree on what the custody and parent time schedule will be between you both, then you both don't need to bring that matter before the court for a temporary order. Far too often, parents end up litigating more than they need to because they don't realize, and because their lawyers don't tell them, that they don't need to litigate every issue. They don't realize that they can, and should as much as possible, make arrangements and follow those arrangements that they agree upon. That stated, I, as a divorce and family law attorney, am well aware that child custody is frequently, even usually, a bone of contention between parents who are separating or divorcing. Still, even parents that don't get along may find it in their individual and mutual best interest to reach an agreement over child custody and parent time instead of placing that decision in the hands of the court. Before you go to the trouble and expense of litigating temporary child custody and support, it wouldn't hurt you at all to try and work out an agreement on these subjects with the other parent first. Even if the other parent simply refuses to negotiate or to negotiate in good faith, you can go to court knowing that, for the sake of your kids, you did your best to reach consensus instead of conflict. Judges don't know, and thus cannot accommodate, your or your children's needs nearly as well as you and the other parent do. For all that they say to the contrary, the truth is that judges usually don't particularly care that much about other people's children and what's best for them. They deal with hundreds and thousands of couples and families, so to an extent you can't really blame them completely. Judges also often have surprisingly obtuse, bizarre, and counterproductive ideas about what the best custodial and parent time arrangements are for your children. So long as you and the other parent are decent and rational people, you should be able to come up with a custody arrangement that is not only fair to you as parents, but what your children need and what they deserve. If you and the other parent can't set aside your own self-interest and posturing for the sake of doing what's best for your children, then frankly, you deserve to have the court impose a child custody and parent time award on you, like it or not. If you and the other parent cannot reach an agreement regarding child custody and parent time so that the court is left to make that determination for you, then here are the factors that the courts in Utah consider in analyzing and determining what the child custody and parent time awards shall be. First, Utah Code Section 30-3-10 Sub 2. In determining any form of custody and parent time under subsection 1, the court shall consider the best interest of the child and may consider, among other factors, the court finds relevant, the following for each parent. The factors that the court is to consider that are enumerated in section 30-3-10 Sub 2 are in alphabetical order, so I will read them back to you in alphabetical order now. A. Evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, the parent, or a household member of the parent. B. The parent's demonstrated understanding of, responsiveness to, and ability to meet the developmental needs of the child, including the child's physical needs, emotional needs, educational needs, medical needs, any special needs, the parent's capacity and willingness to function as a parent, including parenting skills, co-parenting skills that include ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, and willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. and ability to provide personal care rather than surrogate care. D. In accordance with subsection 10, the past conduct and demonstrated moral character of the parent. E. The emotional stability of the parent. F. The parent's inability to function as a parent because of drug abuse, excessive drinking, or other causes. G. Whether the parent has intentionally exposed the child to pornography or material harmful to minors, as material and harmful to minors are defined in Utah Code Section 76-10-1201. H. The parent's reasons for having relinquished custody or parent time in the past. I. Duration and depth of desire for custody or parent time. J. The parent's religious compatibility with the child. K. The parent's financial responsibility. L. The child's interaction and relationship with step-parents, extended family members of other individuals who may significantly affect the child's best interest. M. Who has been the primary caretaker of the child. N. Previous parenting arrangements in which the child has been happy and well-adjusted in the home, school, and community. O. The relative benefit of keeping siblings together. P. The stated wishes and concerns of the child, taking into consideration the child's cognitive ability and emotional maturity. Q. The relative strength of the child's bond with the parent, meaning the depth, quality, and nature of the relationship between the parent and the child. And R. Any other factor the court finds relevant. Then there are the provisions of Utah Code Section 30-3-10.2, sub 2. That reads as follows. In determining whether the best interest of a child will be served by ordering joint legal custody or joint physical custody or both, the court shall consider the custody factors in Section 30-3-10 and the following additional factors. A. Whether the physical, psychological, and emotional needs and development of the child will benefit from joint legal custody or joint physical custody, or both. B. The ability of the parents to give first priority to the welfare of the child and reach shared decisions in the child's best interest. C. Co-parenting skills, including ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, and willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. And D, whether both parents participated in raising the child before the divorce. E, the geographical proximity of the homes of the parents. F, the preference of the child if the child is of sufficient age and capacity to reason so as to form an intelligent preference as to joint legal custody or joint physical custody or both. G, the maturity of the parents and their willingness and ability to protect the child from conflict that may arise between the parents. H, the past and present ability of the parents to cooperate with each other and make decisions jointly. And I, any other factor the court finds relevant. Okay, we're almost done, and we'll wrap up with the factors the court considers when making parent time awards. That's found in Section 30-3-34. The parent time schedule shall be considered the minimum parent time to which the non-custodial parent and the child shall be entitled unless a parent can establish otherwise by a preponderance of the evidence that more or less parent time should be awarded based upon one or more of the following criteria. A. Parent time would endanger the child's physical health or mental health or significantly impair the child's emotional development. B. Evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, a parent, or a household member of the parent. C. The distance between the residency of the child and the non-custodial parent. D. A credible allegation of child abuse has been made. E. the lack of demonstrated parenting skills without safeguards to ensure the child's well-being during parent time. F. The financial inability of the non-custodial parent to provide adequate food and shelter for the child during periods of parent time. The preference of the child if the court determines the child is of sufficient maturity. H. The incarceration of the non-custodial parent in a county jail, secure youth corrections facility, or an adult corrections facility. I. Shared interests between the child and the non-custodial parent. J. The involvement or lack of involvement of the non-custodial parent in the school, community, religious, or other related activities of the child. K. The ability of the non-custodial parent to care for the child when the custodial parent is unavailable to do so because of work or other circumstances. L. A substantial and chronic pattern of missing, canceling, or denying regularly scheduled parent time. M. The minimal duration of and lack of significant bonding in the parent's relationship before the conception of the child. N. The parent time schedule of siblings. O. The lack of reasonable alternatives to the needs of a nursing child. And P. Any other criteria the court determines relevant to the best interest of the child.